The matter for withdrawal, Your Lordship. For withdrawal, Your Lordship.
You have written instructions
Lordships, kind leave to mention an intra-court mandamus
tomorrow.
I'm praying if the matter can be listed as to be mentioned, Your Lordship. The matter has become infructuous. Pursuant to Your Lordship's order dated May 21, 2026. Your Lordship, the writ petition was dismissed, but the matter pertains to we had filed an original application before the state tribunal, but subsequently, so we filed the mat. So I'm praying if that has to be dismissed as infructuous.
We mentioned tomorrow.
So grateful.
May I have my lord's very kind leave to mention a Group 4 application, Your Lordship. It's an appeal, Your Lordship, from a service matter. With regard to the decision, Your Lordship, the petitioner was suffering from terminal disease, Your Lordship. Thereafter, he was made to retire from his service and he is praying for disability pension, and it has been wrongly assessed as invalid pension.
Which service?
Lordship, he was in the
State or union?
Lordship, he was in the border security force.
You said
So-
group 4.
Group 4. Lordship, Group 6. Group 6. I apologize, Your Lordship. Group 6.
Yes.
Group 4 is revenue matter.
Give it-
Group 6.
Lordship, for inclusion in the list, Lordship.
Yes.
I'm grateful.
Number 1.
The petitioner was paying
And for the respondent, my
so lawsuit because and painful not this week in this matter lawsuit because
As paid list after 1 week.
Item number 2. Lord, I beg to appear on the petitioner.
I appear on behalf of some of the private respondents. I have changed my side.
No, you're still on the same side,
Yes, now.
but representing someone else.
Yes, respond.
Still for the respondent. Yes, when did you file the OA?
Lord, we file OL on 11th of January 2022.
22.
Yes.
And it is pending for 4 years.
Pending for 4 years, my lord. This is a matter, my lord, relating to my lord, recruitment of my lord, homeopathic medical officer. My lord, the person, my lord, got less marks. We are given appointment, my lord, so far as we are concerned, my lord, having my lord obtained my lord, higher marks. My lord, we have been, my lord, sorry,
What was the cutoff?
my lord,
May I tell one thing? Just there is one of the preliminary point.
Huh?
There is a preliminary point. Lordship, my lord, be kind enough to consider the same also. Because my lord, at the my lord, the threshold, my lord, or at the first stage, my lord, the way was my lord, the rejected.
One
by
OA,
fixing an order.
OA was rejected.
Yes. Now, my lord, that was challenged by this honorable court. Now, my lord, the court said that no, there are some substances which are to be looked into by the tribunal again. And so the matter remanded. And my lord, direction, the tribunal be heard again. Now, my lord, at this juncture, when there is an order of this honorable court that the matter be heard by the tribunal again, and when that order still remains, now, my lord, before recalling or modifying that order, whether that matter, my lord, without hearing of the tribunal or no order, can be, my lord, entertained by this honorable court in this way because the tribunal is not functioning. Number 2, my lord, there is an order of this honorable court also that there is a, my lord, question of, my lord, the loss of one forum.
Loss of?
One forum. That is, otherwise, matter could have been, my lord, moved before the learned single judge. And then, my lord, either of the parties, they can come up before the honorable court division bench. So I leave it to your lordship, my lord. I am not pressed in that way, but just I leave it to your lordship.
So there are two things. What is the date of the order passed on the earlier occasion by the coordinate bench?
yes, my lord, on 17th of March 2022.
So therefore, Roger Matthew, he will rely upon paragraph 390 or something.
Now, my lord, your lordship, my lord, kindly consider, my lord,
He is remediless. The second issue which you raise,
I leave it.
let's see.
My lord, initially, my lord, I moved before the Honorable Tribunal. My lord, learned tribunal had been pleased to, my lord,
Regarding filing of a writ petition, this bench has
I
decided that
know that
under what circumstance. So once it is pending before the tribunal, prior to the tribunal becoming non-functional, then this is the remedy. Post September, after September or since September, they will have to go to the single judge bench. That we have laid down until as of now, as we don't know that that order has been upset.
yes, my lord, that is
So
still
this-
operating in the field.
Yes,
My lord, initially, my lord, I moved the tribunal, my lord. Tribunal, my lord, had been
And
pleased.
another point, Lordship, there are more than 100, my lord, the private respondents. My lord, today I appear not for all the private respondents who are the mother doctors.
so we'll make sure, don't let us see what it is, yes.
My lord, initially, I moved the tribunal. My lord, tribunal had been pleased to, my lord, dismiss my original application.
So there was a process initiated
Yes.
in 22
Process initiated, my lord, in 2022.
for medical officers
The process
homeopathy,
initiated in the year 2019.
19,
19.
medical officers homeopathy.
Homeopathic, this is, my lord, in respect of homeopathic medical officer. My lord, it was, my lord,
Another state government.
another state government. Now, my lord, the process was initiated, my lord, subsequently, my lord, applications were invited. My lord, I also submitted my applications, others also submitted their applications, interview was took place, subsequently, my lord, selection was made. Now, my lord, initially, some persons, my lord, who was, my lord, initially selected as, my lord, PWD candidate, they were subsequently selected as, my lord, unreserved candidate. Now, my lord, so far as, my lord, unreserved candidates concerned, my lord, cut-off marks is 82. They got, my lord, 73. Well, they were selected, my lord, as so far as, my lord, unreserved candidate is concerned. Now, my lord, not only that, my lord, they at the time of, my lord, submitting applications, they submitted their application, my lord, PWD certificate, well, which is much beyond the, my lord, cut-off date. It has to be submitted, my lord, 712020. They have submitted their applications, my lord, in the month of October, my lord, 2020. So, well, there are series of irregularities are there. But I pointed out all these things before the tribunal, my lord, rejected it. But I moved this honorable court, my lord, kindly have a look, my lord, page 162, the order passed by this honorable court on the first round of litigation. May I just place it, my lord, page 162. The instant writ petition is filed challenging the order number 3 dated 1st of February 2022, passed in OA number 13 of 2022 by the West Bengal Administrative Tribunal, by which the tribunal application was dismissed on the ground the petitioners have not explained how the entire selection process was carried on extraneous consideration, and entire tribunal application is based upon a new news published in a Bengali news channel, and therefore it cannot be considered as a foundation of the pleading. In the course of hearing, it appears that the petitioners are the participant in the recruitment process and claim to have secured 81% and 82% marks respectively. The allegations is made in the tribunal application that the candidates who secured 73% and 75% marks have been selected, sparing the petitioners who obtained the higher percentage number. It was also alleged that the private respondent number 108-109 were inducted in the panel of PWD category, but appointment has been made to the post of reserve category, reserve for the general category, which is impermissible. The petitioners have annexed the panel published by the competent authority in order to corroborate such allegations. It is further alleged that once the cut-off marks in the general category is fixed at 82.5, the person securing 73 and 75 marks cannot be included in the general category. Furthermore, it is alleged that some candidates who do not have expertise or the knowledge in the House of Seats are not entitled to be appointed in the general category. Such being the pleading and supportive documents are also annexed to the tribunal applications. We fail to appreciate whether the said tribunal application is bereft of any foundation. The cause of actions is a bundle of fact if proved. Will invite the court to decide the reliefs claimed therein. The importance of pleading cannot be eroded if there is no such case made out, not any dispute is raised, if there is sufficient material made in the applications, which is the bedrock of the cause of actions, and for reliefs claimed therein. We do not find that such pleading should be.
And this was in relation to an order passed by the tribunal. Where is
Yes,
the tribunal's order?
Tribunal orders, my lord, you will also get it, page 219.
Wow.
219.
These persons you have made allegation against their parties. Let us issue notice that, let them come.
But so far as service is concerned, so far as I serve them by email. Now, if you lost so once, this is a process, in respect of entire recruitment. So let me make an advertisement or publication in the newspaper so that it will be easier.
These persons
These
against
persons were served by email.
you serve a proper notice.
Yes.
Which are they at serial numbers?
It starts from serial number 8 2 109.
All. No, you have made allegation against some person at
I
serial.
made allegation some of them. So,
Yes.
so let me some sub so far as serial number 8 100 809.
Three persons.
800, 903.
And how many are you representing, Mr.?
Total as on date 237. Total
No, how many?
So far 8 is concerned, my lord, I have been, my lord, instructed to appear. And so far 109, 109 bollen na?
yes.
Just a minute, may I ensure myself?
108.
8 and 109 also.
Well,
So, my lord, let a copy be served upon me.
Give him a copy.
That will,
Yes,
my
yes.
lord, suffice to.
And regarding service on the remaining, we will see.
But in fact, my lord, I have been instructed to appear more than 30% till date.
Then complete your appearance, file it so that we know who are represented, then we'll proceed further.
My lord, on the
You
next
file your appearance within this week, we will keep it in the next week.
my lord, there, my lord, the serving doctors in my lord several and my lord district hospital
Must be, it is a process of 22.
in North Bengal or my lord,
No, whatever.
districts. My lord,
You
they have-
complete your appearance within a week, we will take it up thereafter, and if further notice is required, we'll see. Maybe more will turn up
Yes.
through you, we don't know. Mr. Sen, learned advocate, submits that he is appearing upon instructions to represent some private respondents. So let him file his, let the wakalatnama for representation of the
Collect it from the office of the GP.
Lord, I shall reply on the next day, my lord, when I shall draw your lordship's kind attention to only 3 or 4 paragraphs from my affidavit, my lord, affirmed therein, and my lord, certain, my lord, other notifications, my lord, that those are all incorrect, my lord. Let
Sir, আপনাকে দিয়ে দেবো কপিটা।
হ্যাঁ এই আমার হ্যাঁ
Number 3.
In this matter, your lordships had directed me to file an affidavit in opposition, lordship. Lordship, the records cannot be traced. Lordship, this is a very old matter. My instructions are written instructions that the main file was handed over to the advocate in the court before the tribunal. He has passed away. Lordship, we are still searching. So I think, Lordship, the impugned order has dealt with all the pleadings in details. Therefore, Lordship,
Can we proceed?
I think it's better to proceed without the affidavit.
Let us.
My lord,
And your opposition is already on record
no,
In the reply is on record before the
from the tribunal.
yes,
Oh,
that is record, but it has not been annexed to the petition. My learned friend has not done that, but the order reveals the reply rejoinder in details, lordship.
Let's see if we can proceed.
My lord, the petitioner, original petitioner, he was an employee of the state of West Bengal. He joined as a lower division clerk in the Directorate of Health Service, West Bengal in the year 1963. And thereafter, he was promoted to upper division clerk in 1990. Unfortunately, in 1991, there was a complaint against the petitioner and Uluberia Police Station case 220 dated 25th September 1991 was initiated. And that case, and he was suspended thereafter, immediately thereafter in the next month. However, later on 16 December 1993, this Honorable High Court quashed the entire proceedings of the Uluberia Police Station case. Thereafter, immediately thereafter, on 12th February 1994, again the Superintendent Uluberia Subdivisional Hospital filed a complaint on the self-same charges, and the new police station case number was 42. Now, on this basis of police station case, again the suspension order was revoked initially by the state, and he was allowed to join the post in terms of the Honorable High Court order. Your Honor, at that very material point of time, he was having an eye surgery. He could not join, and he had made an application for sick leave. And after his eye operation was completed, he joined his services. But on the next day, he was asked to report and sign the attendance register before the chief medical officer on 8th February 1995. On the very same evening, he was again suspended. Now, the disciplinary proceedings started, Your Honor, and Your Honor, from the impugned order, it will reveal that there was some political involvement was there, and he was not allowed to join by the ruling political party at that point of time. So because of agitation, he could not join, and he was also suspended. Now, when the disciplinary proceedings started, he was not allowed to cross-examine the witness, and he was not allowed to submit his evidence. That is the main matter where we want to submit respectfully that because of the violation of the doctrine of natural justice, my petitioner could not explain his case, and again he was suspended by passing the necessary order. Now, with that order, we had challenged before this single bench, this Honorable High Court. The Honorable High Court has said that you have to go back to West Bengal State Administrative Tribunal, because by that time the tribunal started functioning. When the matter went before the State Administrative Tribunal, my case was dismissed, and in the meantime, Your Honor, in the criminal court, rigorous imprisonment was imposed on me, which was later challenged before this Honorable High Court. By this time, my petitioner died, and the Honorable High Court in that case had dismissed that rigorous imprisonment order. Now, after the death, wife and children has been substituted. So here, our main point is that the petitioner, the employee, was not given the scope to explain his case. The criminal proceedings were all quashed, and since it is a disciplinary proceedings, and since there had been a violation of natural justice, if you allow me to read the impugned order, then the matter will be clear, Your Honor, at page number 3 of the impugned order. The first point I would like to highlight that at about 8 p.m. on the same date, the applicant received an order signed directing him to report to CMOH Howrah from the next day because of the ongoing agitation by the employees who were reportedly against the presence of the applicant in the hospital. Your Honor, I would like to highlight this point. Because of this political involvement, the disciplinary authority who was making the inquiry and was giving an opportunity, and notice has been said, but ultimately it was not a fruitful hearing because of the agitation. The hearing took place in a different place, and he was not allowed to cross-examine as well as submit his evidences. It is already on record. And the next point is, Your Honor, the issue was regarding payment of salary to the Group 4 employees. And making salary bill payment of Group 4 employees, and he was not at all involved in Group 4. He had the duty to make payment of Group 3, but as because he was one of the responsible person, he had to sign in those documents, but no examination of the expert handwriting, nothing was done. It is all reflected in the order, but however, the Honorable State Administrative Tribunal has dismissed my case, and for that reason, before you, Your Honor. Another point I would like to mention that in one interlocutory order, directions was given by this honorable court to make to pass a order regarding the outstanding salary which could have been payable to the petitioner, and no action was taken. A contempt proceedings was initiated, but thereafter, unfortunately, since the petitioner died and there was no communication, the case had to be dismissed for default, and then my lord has restored the application. At this stage, we are now here. What? Good. Your Honor, page 5, refusal to supply copies of deposition of witness to the charged officer and not allowing the cross-examination of witness has vitiated the entire proceedings the applicant submits. It is mentioned at page 5 of the order, impugned order.
Yes. So which documents were not supplied? Where have you stated it before the inquiry officer?
My lord, this is already recorded in the order sheet, my lord.
Where have you stated before the inquiry officer that some document you are requiring, unless it is given to you, you cannot participate in the proceeding?
Yes, my lord. Just kindly give me a moment, my lord.
Yes.
My lord, on two occasions I have done. First is at page 59.
Yes.
59 to my lord to 69. If you allow me to read, my lord, I received your memo on the reference number on 20.
No, we are not going to read this.
That I have not been allowed by your appointed inquiry officer. Only this portion.
Yes.
Dr. Aniruddha Kaur, he conducted the inquiry on 25th April 1995. This is at page number 59, my lord.
Yes.
To cross-examine the witness who are sustained in annexure 4 of the impugned charge sheet framed against me via your memo number.
What is the date of the inquiry report?
The date of the inquiry. My lord, prior to this, at page number 52, in terms of the notice, I had requested to allow me to submit. That is at page number 52 to the Director of Health Service and the as well as page number 46.
Right.
It is at page number
May 95.
Inquiry report. So this is not, we are asking you,
yes, my lord.
before the inquiry officer, a charge memo was issued on 26/1995.
Yes.
After 26/1995, you must have appeared in the proceeding.
Yes, at page 46.
So in the proceeding, when you appeared before the inquiry officer, which document you requested for, which was not given to you? Don't show us something after the inquiry report.
No, prior to the immediately after the charge sheet was prepared, at page number 46, the particular documents have not been mentioned, Your Honor. If I read, then this will be clear. At page number 46. With regard to the articles of charge, I framed against me under Annexure 1 and 2, I say that I never prepared any bill of class 4 staff at any point of time.
So this is your written statement of defense.
Yes.
Very well.
Yes. Written statement of defense.
Let us see. Let us go through it.
At page 46.
So no document required in this written statement of defense. There is no request for any document in this written statement of defense.
2 points were there, my lord. One is to cross-examine the witnesses.
See, there you have just said documents were not given to you. You have also said you are not allowed an opportunity to cross-examine. These are the two procedural infirmities which you
Documents
are
were allowed to submit. The charge sheet was given to me that we have annexed at page number 49. The articles of charge is at page 49.
Again, we are saying you have raised an issue that you are not allowed documents which you required.
Not allowed to submit documents in support of my case.
So which document you wanted to submit as per your written statement of defense? Nothing. There is no such.
My lord, the petition.
Now, the second thing is no cross-examination.
Yes, my lord.
Now let us see the inquiry report.
Yes, my lord.
Where is the inquiry report?
at page 54, my lord, the inquiry report.
Internal page.
Internal page হচ্ছে internal তো 1 থেকে শুরু, annexure P9, annexure P9 টা দেখুন।
delete করে নিচ্ছি। প্রত্যেক আছে।
এটা আমি
এটা তো আছে। কোনটা ভেতর থেকে কোনটা?
ওটা অন্য জায়গা থেকে,
আচ্ছা।
এটা রিপোর্টটা, তখন
হ্যাঁ, এটা তো
পড়ছিলাম
report।
আমার রিটেন
ওটা
স্টেটমেন্ট।
তো দেখছি।
At page, my lord, at page 2, third line, Sri Sengupta claims that he had no scope to check the bills since the bills were placed before him during tiffin hours and the same was placed at the
Sir,
last date of
you are not
publication.
arguing an appeal. You are not arguing an appeal. And charge memo, where is the charge memo? Page 58.
That is at page number 43, articles of charge.
5th February 1995. 42 it starts. No, that's a memorandum.
Yes, come to page 45.
Right.
Annexure 3 and annexure 4. Which witness has proved any of these documents in the inquiry? From the inquiry report. Is there a single person who has appeared as witness?
This, from the report, Lordship, there is one Vishwanath Rai who has
Any witness has appeared in the inquiry?
uh, has been, Lordship, if your Lordship comes to page 54,
Yes.
the last paragraph, I mean, the report really doesn't say witness number 1, 2.
Yes.
I find that the manner in which government money was misappropriated for years after years have been described in brief in my report by Sri Vishwanath Rai. As the copies of the bill and acquittance roll indicates, all bills bear Sri Sengupta's put up signature before the same obtained signature of the superintendent and DDO. All corrections and overwritings too bear his signature. So this is
Any witness has appeared.
the report is rather, I mean,
There is not, it appears that not a single
it's written in a very different way, not the, I mean, not the way. It's not narrated at the,
That document issue is appears to be baseless. There's no such foundation in the inquiry report. This cross-examination business, unless there is a witness, where is the question of cross-examination? Only if a witness is examined, then only the question of cross-examination will come. So which witness you have examined? And the nature of charges where there is passing the buck, somebody is saying he is responsible, somebody is saying the other is responsible. So how do you pinpoint that this gentleman who has committed this? What is the basis? You have stated out in Annexure 3 the documents you rely upon, 6 documents. You have stated 5 witnesses you propose to produce in the inquiry. Not a single witness has been produced. Inquiry officer is discussing casually that he says this, I feel this, he says this, I feel this, and he says proved. Where is the inquiry? Just go through the inquiry report.
the only matter. But এটাকে দিয়েছে inquiry.
Yes. So from the report, what we find is 23 to 95 is the charge memo. Inquiry officer appointed, presenting officer appointed on 29/3/95. In the meantime, he submitted his written statement of defense on 2/3/95. 18/4/95, the inquiry officer himself went to inspect the documents along with the presenting officer in the office. On 25/4/95, his statement was taken. Which proceeding after that?
Lordship, it's very unusual, but Lordship, the procedure for imposing penalties as per the rule, Lordship, that is also, I find that.
No, just see the first, second, third, fourth paragraph from page 54. On 2/3/95, he has submitted his written statement.
Yes.
Now, after that, the presenting officer appointed on 29/3. Now, on 18/4, the inquiry officer, along with the presenting officer, visit the hospital to go through the documents. And on 25/4/95, statement of this gentleman was recorded. After that, what happened? Nothing. No inquiry. In his deposition, he has said so and so. I think it is the other way. So therefore, charges are proved.
If your Lordship kindly comes to Rule 8 of the
Page?
West Bengal Services Classification Control Appeal Rules, Lordship.
Yes.
The procedure, Lordship, is rather unusual, Lordship.
Yes, the procedure is presenting officer will present the case on behalf of the department. Yes.
I have the,
We have it.
10, Lordship.
We have it. We have a copy. His penalty is dismissal.
Penalty is dismissal.
Where is the compliance with sub rule 9 of rule 10?
Lordship. তারা examine করে। এটা
After 25 or 95, he appears. After that, there is no.
presenting officer, তাই তো বলছি। কারণ
In his deposition, he has admitted this.
then comes the document. Orderটা order রিমুভালের অর্ডারটা মানে ইমপ্রিমেন্টেড। হ্যাঁ বলো। ফাইনাল অর্ডারটাও তো দেখতে পাচ্ছি না। পেজ 17 প্যাগিনেশনটা আমার ঠিক নেই। wait, এটা তো ওর সেকেন্ড চোপার, সেকেন্ড চোপার P12 না দিস ইজ না এটা তো ইসের অর্ডার 95 এর অর্ডার। Lordship, in the second chopper's notice, he said that no witness has been produced. That is the petitioner's contention.
No, that's clear from the inquiry report. If there was any
That's-
witness,
it's
they would have
also been-
they would
it's
have
also-
considered the statement of the witness, but there is no witness.
No, there is no, I mean, they have not a single witness. That is the contention of the, in the second chopper's notice also. No, no. No. কারণ এটা লেখা Vishwanath Roy is a witness, Lordship. Vishwanath Roy, the name referred to in the report, he is a cited witness, Lordship.
Vishwanath Rai is the person with whom it is said he is in collusion.
That is his allegation, but he was a witness and Vishwanath Roy has been,
So at least he was required to be examined.
Lordship, he is a cited witness, Lordship.
But he has
Okay.
not been examined. You see article of charge number 2 at page 43, sixth paragraph from the top. It has been reported that the said Sri Sengupta, while preparing pay bills, has increased so and so in collusion with Sri Vishwanath Rai LDC. No inquiry.
Annexure for the list of witnesses named Vishwanath Roy.
He is named there.
Yes, Lordship. That is, my brief is not paginated. The charges, Lordship,
Yes, he is the number one.
he's number one.
Sarkar is another person posted like the
Vijendranath
petitioner.
Sarkar, Treasury and the subdivision.
Sarkar is also a UDC like the petitioner. Then there is the treasury officer, the SDO, superintendent. The superintendent also was not examined because after the bills were allegedly signed by the petitioner, it was placed before the superintendent.
It was placed before
He has also not been examined, nothing. Copy of FIR, inspection report. No material. Plus, nothing has been done by the presenting officer. There is no inquiry. He satisfied he cannot be. Where is the order of dismissal?
Lordship, order of dismissal is P10. Lordship, page, Lordship, annexure P10, order dated 20th June. No, this is the report.
Annexure P12, page
P12,
70,
page
70.
P12. 24th August 1995. 26.
What is the date of annexure P8?
P8.
Is the date available in your index? Can you?
Second.
Date of page 52.
Review statement.
Page 52. 26 April 1995, that is at the bottom of the letter
24.
at page 53.
26.
Oh, yes.
Go to the left-hand corner, down bottom.
And you were saying P12,
Yes.
the punishment
Order is
order.
at Annex P12, page 70.
And where is your reply to the second show cause?
Lordship, that is
Second show cause is of 28 June 2095.
The
After
reply, copy of the screen. Reply is at Annex P11, page 59 to 69.
how that can be, sir?
The date is
date is not there.
Oh, this is your reply. Yes, this is the second.
yes, date is on 24th July
Yes,
1995
yes.
at page 72.
Yes, there is no inquiry. Take down. The learned advocate.
Or I appear before the petitioner.
This is the first can application. Can number?
That's filed, my lord.
Can number 3.
My lord, can number 3.
The application is filed. It has to be served.
My lord. Sir, my lord.
It is. Oh, then notice will have to go.
She has not came today, man.
This is application for restoration. The
Number 5.
For the petition. I'm filing the supplementary affidavit. Initially, I came before this court, praying for expeditious disposal of my way application before the tribunal. Thereafter, the scenario has changed. Now, tribunal is absolutely unmanned, there is nobody, as my lord is aware. So that's why, I have brought the supplementary affidavit, and I have served.
no, but
Also,
does this change in circumstance give rise to any other prayer also today?
then kindly grant us liberty to withdraw and then file a fresh.
Sir, you have not just, please see this order. The learned
Number 6.
I'm deeply. Item number 6, my lord, one
An annexure has been wrongly misplaced or has not been annexed properly. So I prayed before to give me one liberty to annex it. One vital document.
Which annexure?
Annexure
It is from the tribunal record.
from the tribunal record as well as also I should have annexed it. It was misplaced somehow.
No.
It was
This is
in the annex.
WPST arising out of OA. That annexure is in the OA, or it is something outside the OA.
It's outside the room, my lord.
Then we'll admit.
It was supplementary. It was supplemented in the.
It was there in the record.
It was in the record.
So that was supplementary affidavit you have not placed.
No, that is a mistake. That is a mistake, I feel.
This is pending before the tribunal. When did you file it before the tribunal? What is the date of filing of the OA?
It was filed. আরে প্রথমেই দেখ না 220
Lordship, no affirmation date has been given in the OA. That's why I'm not able to
What's the
understand. when
number
it
of the OA?
The number is 609 of 2024.
2024.
The learned advocate for the
In the Public Service Commission. Can copy be given to the commission also, Lordship?
give a copy.
Item 7.
Appellant is not here. I can't see. But this is Lordship had heard this matter briefly. And the appellant had concluded its the submission. This is with regard to specific performance of an oral agreement.
Yes.
Lordship had recorded the submissions as well. But I was in the midst of my submissions, but then. But I can't do it today. There's a resolution and the appellant is not. Lordship will make it not today when it will come back tomorrow.
Item 8.
8, my lord, this is my review application and kindly recalls. And my lord, one contempt application was filed on behalf of the appellate, my lord. As per my instruction, the talks of settlement has been going on between the parties. Exactly my lord, what I'm saying. My lord, kindly recalls this is the matter where in chamber, my lord.
Oh, yes.
Now, my lord, in the meantime, what has happened? The daughter has got admitted in an engineering college and the father, as my lord told before, my lord, in chamber, he has paid the fees of the college. And the next semester fee, when it's due, he will pay the same. Now, my lord, with this gesture of both the sides, my lord, it is being mutually resolved.
Oh, great.
That he will carry on with the education expense of the child as agreed before, my lord. And with regard to the 21,000 which he is paying, he will keep on paying. And he has paid up to date, there is no problem. And with regard to the quarter which the wife is enjoying, the police quarters, for which a portion of the salary is being deducted from the husband's salary, she has agreed to leave that place, and that amount which the husband now gets,
That he will give.
that he will keep in the daughter's account. Separate account will be created out
Benefit of the child.
benefit of the child. That will include to the benefit of the child, till she becomes able to earn herself.
It seems to be moving in the right direction.
Right direction. So if by this order, the order can be
So we
modified.
will adjourn it for some time, or we should dispose it.
But if this is agreed, my lord, the order may be modified and it can be a court's order and he is complying with it.
Therefore, we are saying we should adjourn it for some time. You will have to give us the terms.
Very good.
Very well. Just make it out and give it to us so that we can record it. The issue
নাম এই নাম
Item 10.
Call the chamber.
Board has committed an error.
My lord, my application for review, my lord. My lord, 2 points I have was dropped, my lord, on the face of record, my lord. My lord, your lordship kindly your lordship judgment kindly see. Second para, my lord, the specific assertion of the respondent in the present proceeding is that no such application for voluntary was made by the petitioner. Therefore, there was no occasion to consider an application. But in the matter, my lord, I made application, my lord. My application for voluntary retirement was forwarded to the AG Bengal, my lord. In the manner I have said so in the manner grounds at page 5, para 9 and 10.
You want to re-argue the matter?
Yes, but that day, my lord, in the reply, I said it, my lord. But that day, my lord, matter was, my lord, job matter not considered, my lord. My lord, this is the application, my lord, for voluntary retirement, which was forwarded to the account general, my lord, principal of account general. And that application is still pending, my lord, on record. This is this based on error in the order, my lord, face record in the, this is the record. Not forwarded, my lord.
সেকেন্ড স্যারের একটা কপি দিন। নেই একটা গেছে।
My lord, I have said so in the reply, my lord. That day, my lord, was not considered at the time of hearing. Your lordship said, my lord.
How that makes a difference? How that makes a difference?
Well, on the face of record, my lord, the your lordship said the no application for voluntary was
He have said.
not your lordship said, but in the your lordship judgment.
The issue was whether the proceeding was vitiated or not.
I'm just reading, my lord. The unauthorized, in the view of the fact, the specific assessments of the respondents in present proceeding is that no such application for voluntary was made by the petitioner. Therefore, there was no occasion to consider an application for voluntary. So application was made, my lord, in time. When the order was passed by the
What relief you claimed in the tribunal?
voluntary retirement.
What relief you claimed in the tribunal?
Tribunal, my lord, regarding voluntary matter, voluntary, no order was passed. Only dismissed.
What relief you claimed before the tribunal? Any relief regarding VRS?
My lord, before the voluntary, my lord,
What relief you claimed before the tribunal? We are asking you third time. Regarding VRS, what relief you claimed? Show from the prayer in the OA.
my lord. Only 2 points I have.
Sir, please tell us.
Before the
You are indulging in such kind of litigation which prima facie we find to be a luxurious litigation. So tell us why you have filed this review.
before the tribunal.
What relief you have claimed about VRS?
That was not made, my lord.
Then
And another, my lord, these are my on the face of
take down.
record.
As an advocate for the
my lord, before
The next case.
dismissal pass the order. That page, my lord, your lordship.
This is coming up, Lord, after notice.
Contempt.
But the affidavit of service, Lord, may be permitted. Just for record, if your lordship permits. So this is that matter where the non-executives, Lord, they were, Lord, brought in and Lord to the post of executive. But Lord, there was a pay anomaly.
Upgradation of their post.
Upgradation of their post.
Now we
There was
remember.
pay anomaly. And this is, in fact, your lordship's, Lord, affirmed, Lord, the view of that was taken by
The
the
Honorable Single Judge.
and Lord, the direction was given to implement it. They have not done any implementation. They issued an order which complies with some other judgment passed by some other high court. This is where we are, and this is the reason. Lord,
That
why-
order is on record.
Yes, with the leave of court, Lord, after the contempt application was filed, they issued this order. Therefore, Lord, with the leave of the court, Lord, I filed the supplementary affidavit. That order is also, Lord, annexed to the
So there are two things. One is if we have affirmed the order of the single judge, we are to consider the contempt, or it is to be considered
But
by.
if the order is affirmed, Lord, then your lordships will have the jurisdiction to hear the contempt.
No, we have.
In fact, your lordship is pleased to pass a detailed order.
Detailed order,
Detailed
modified
judgment
it
in order.
also.
Therefore, my lord, I am not going to take the point that it must go back to your lordship is there. I would much rather have it before your lordship.
Whole thing is
So
that
according to you, you have complied.
According to us, this is that I tell you, lordship, very frankly, your lordship will kindly take the order which has been passed in pursuance of your lordship's direction. That is in the
page
supplementary.
21 of the supplementary act.
তুমি পড়া যাচ্ছে তোরটা আমারটা পড়াই যাচ্ছে না আমি অন্য একটা অন্য নিয়ে এসেছি এই যে আমি নিয়ে এসেছি but I don't know whether your lordship copy is illegible because the copy in my affidavit is page 21 supplementary affidavit.
Because Lord, the copy which was served on us is this is the.
So I'm not blaming you. Maybe we are to blame, but then again, my lord, it is not very legible.
Unfortunately or fortunately, by now we have become used to these things. So we know how to read these documents.
Lord, I'm really sorry, Lord. If necessary, we will type it out. We'll type it out.
About, I am sure Mr. Kaur will bear me out, that about 20 years back, I remember one learned judge threw the paper at the council. He said, I am not going to look into the paper, you take it back. So your lordships are much more gentle. So, my lord, I have no complaint on that score.
Yes, you were saying something about this.
Yes, well, this is the order dated 28th April 2017. Kindly, my lord, come to the first page, the last 3 paragraphs about which my learned friend had been complaining. And whereas a similar issue regarding adherence to DPE office memorandum dated so and so also came to be examined in judicial proceeding before the Honorable High Court of Madhya Pradesh at Jabalpur in Coal India so and so. And whereas the matter was examined at the level of the Ministry of Coal, MOC, Government of India, where a 4-member committee under Joint Secretary BPP was constituted, and upon detailed examination, the committee recommended upgradation of pay scales of executive cadre employee, with recommendations were accepted by the competent authority at MOC and communicated to Coal India Limited by letter dated 31/12/2025. And whereas the Coal India Limited thereafter issued office memorandum dated so and so 2/2/2026, whereby the pay scales of executive cadre of employee were upgraded and notional effect was given from 1/1/2017 and the monetary effect from the salary of January 2026 onwards.
27.
26
onward.
onward. And then whereas under the said revision the pay scale of E1 grade stands at rupees 61,000 to 1,50,000, with a starting basis of rupees 60,000, which is higher than the starting basic pay of the highest non-executive grade A1, which stood at rupees 47,800. And now, therefore, the matter has been examined in terms of the directions of the Honorable High Court and the applicable policy provisions, and the following is recorded. Then the grievance of the petitioner arising from a situation where upon the upgradation in the executive cadre as subordinate engineers in E1 grade, they were in certain instances drawing lower pay than the employees continuing in the non-executive workmen cadre. The executive and non-executive cadre are governed by the distinct structure, the former being under DPE guideline and the latter being bipartite negotiation wage agreements. Then pursuant to the implementation of third PRC and subsequent upgradation of executive pay scales by Coal India Limited, dated 2nd February 2026, the entry-level pay scale of executive grade E1 stands placed above the highest non-executive grade this was the complaint. Highest non-executive grade as on 1/1/2017, accordingly pay structure upgraded, so and so, is adherence to so and so. And in view of the above, in case then this order has been passed. Now, I've got this submission to make. I have looked into this order. To be very frank, my lord, I have not seen, my lord, what order was passed on the 2nd of February. But your lordship's order is of March 2026. Therefore, my lord, whatever has been done pursuant to Jabalpur order, well, we'll have to, my lord, comply with your lordship's order. So I have not looked into it. I have called for all these records. And if I find, my lord, that your lordship's order is something more than what the Jabalpur order is, then, my lord, they will have to comply with it. Kindly grant me some time so that I can look into the matter and come back before your lordship. And my lord, I shall try and justify my, if it is not justifiable, I shall personally come before lordship and will say, my lord, we will comply with the order.
How much time you
give me, my lord, the 4 weeks time for everything.
Lord, I tell your lordship's judgment is very clear. Our parity will have to be, Lord, considered from 2011. That's number one. Number two, the arrears. There is a date fixed for the purpose of payment of arrears. What they have done, pursuant to Jabalpur High Court, they have fixed, Lord, the scale with effect from, Lord, 1/1/2017 with no arrears.
So therefore, he is submitting that this is not the final stand, subject to what instruction we may have. So there's no point in going into this right now.
No, I'm not. That's the reason I didn't open the brief.
We understand, we appreciate what you're saying, but since it is in the process, we don't know ultimately what will emerge. But as and when the occasion arises, we may have to consider this. You are instructed 4 weeks.
4 weeks is asking for, my lord. I don't know, my learned friend is agitated on that. So I am not going to make any comment.
I only say that, Lord, it was a time-bound contract. The order was extremely time-bound.
That we see, we have to appreciate the stand being taken by the learned advocate. We have the respondent. If he is trying to resolve, let us see.
Lord, if the time could be, Lord, cut down and, Lord, some, because these people have retired. They are retirees, Lord.
We'll give them 4 weeks. We hope that better sense will prevail. If not, then we'll proceed as it is.
Let me see, my lord, if it can be sorted out, my lord, then that will be for the benefit.
No, of course.
Mr. Mitra Leonard, Senior
Actually, then it would be. If it is just for completing the formality of consultation, then it could be.
Item 12.
The present determination of this court
Item 13.
This matter is relating to non-payment of provident fund dues. Non-payment of provident fund dues, more than 5 crores are still due.
You are the?
I am provident fund commissioner, my lord, respondent.
Why you are keeping it due?
My lord, they are.
My lord, may I say? Initially, my lord, we had received a notice during the COVID period, my lord, that
You are the organization.
yes, my lord. I'm a, my lord, established industry, my lord. Lordship knows, my lord, it was suffering from losses, my lord, for several decades, my lord. Now, my lord, we came before this, my lord, kindly allow us, my lord, to liquidate the damages, my lord, so that we can pay equal installments, my lord. That was, my lord, dismissed. Subsequently, my lord, we preferred, my lord. But the appellate court, my lord, has granted that liberty to us, my lord, and we have liquidated the entire amount right now, my lord. The amount which was involved in this particular appeal has been already liquidated, my lord. Subsequently, we are going on payment. They are recurring dues, my lord. We are gradually, my lord, we are liquidating the same, my lord. If your lordship, my lord, can take the instruction which my lord is submitted, that is on 5th of December 2023, my lord. That was my.
Yes.
Here, my lord, the instruction specifically says, my lord, the amount which has been involved in this particular application, my lord, has already been paid off to us, my lord. Subsequent.
Then what remains in the?
Yes, my lord. In each and every occasion, my lord, this is the section, my lord, which has been made by the PA authorities that we are, my lord, defaulted, my lord. It is our part on our part also, my lord, that we are going on paying. In spite of the fact, my lord, we are suffering a loss, my lord.
Sir, you are the appellant.
My lord.
You say you have complied with or discharged your liabilities.
I am not saying, my lord, he is saying, his authority is saying, my lord, the amount which has been involved in this application has already been paid off by us.
Then why you want to carry on with the appeal? That's what we are asking you.
My lord, if the appeal stays, my lord, that we are going on, this will kill that, my lord. Because otherwise, my lord, again, my lord, they will send us a notice for attachment, my lord. Again, my lord.
So to prevent the notice, the appeal should be kept pending.
My lord, so that, my lord, we can.
You are submitting.
Yes, my lord. My lord, some protective measures should be given. My lord, we are going on paying, my lord. This is my prayer before your lordship, my lord.
Please give us some law to support.
No, no, my lord. There is no.
What kind of submission?
There is no such law, my lord. This matter is pending, my lord. They have again served us with a notice, my lord.
They will keep serving you every time there is a default. This can't be an anticipatory appeal.
But this is the instruction, my lord, which I have.
At best, we can say if there is a cause of action, you can avail the appropriate remedies.
My lord. And they will, my lord, consider representation, my lord, liberally, so that, my lord, we can get that opportunity.
Representation and all in anticipation.
I don't know, my lord.
Exactly, we don't.
That is, my lord, there is a shift of management, my lord. Actually, we received the notice, lordship, kindly.
As of today, as per your stand, the subject matter of the appeal does not subsist, there is a likelihood that similar demands or directions may be issued. So if and when it happens,
we are requesting them kindly provide us the account so that we can reconcile, my lord. Even they fail to do so, my lord. They say no, 4 crores is due, you have to pay right now. We are writing them to latest, my lord, kindly give us the account.
the order under appeal.
My lord, initially, my lord, the order was, my lord,
There was a direction for some quantified amount.
yes, it was not 4 crores, my lord, against which we came. Now, after filing of the writ application, we came to know, my lord, 14 crores was due. Subsequently, my lord, 14 crores has been paid by us. Now again they say 2.5 crores still due, my lord. Now we are going on paying.
It will occur every month or every 6 months, every quarter.
Implies contribution which has already been deducted from the wages of the poor, that even not been paid. That is a criminal breach of trust. My lord, no, and this is covered by judgment of
what judgment? His appeal he is saying is infructuous. Why do you want to take us in the merits?
It has been, your lordship kindly pay the
You can
last
dispose it off as infructuous, giving the liberty to.
Your lordship, my lord. Your lordship kindly see the penultimate paragraph of this instruction, my lord, which he has submitted, my lord.
So this is now July, August, October 25. This is must be subsequent to the cause of action. So
I'm going on paying, my lord.
My lord, kindly see this
Again.
coordinate with this honorable court judge.
no, we are not going to see anything. This is infructuous. Why should we see?
No, say, my lord, it is his instruction, my lord. Here, even I say, my lord, I'm going on paying, my lord.
Current dues he is not paying.
Dispose of, my lord.
The learned advocate for the appellant. Pending applications disposed of, all interim orders vacated.
Appeal and application post disposed of.
No, application is pending after disposal of appeal.
Item number 14, my lord. Am I audible to your lordship?
Yes.
But item number 14, my lord, I appear for the appellant. My lord,
Yes.
this matter had last appeared, my lord, in 2021. This has suddenly come in the list. My lord, I'll have to take some instruction, my lord, from the client and come back. I was only beseeching your lordship to, my lord, kindly accommodate us for 1 week. Allow us to come back on the next week, my lord.
As prayed by the learned advocate for the appellant, appearing virtually. We adjourn the matter 2 weeks to enable him to take instructions. List
I'm
on.
most grateful.
I'm grateful to you.
The respondents are represented.
I'm very grateful, my lord.
Sharat.
Sharat.
15.
Sharat ko hai.
Here for the response.
It also seems to have become infructuous.
None appears on behalf of the appellant. Respondent is represented. In this song, 1 week. Yeah.
Array 16.
None appears. Same order. 1 week. None appears for either parties.
Item 17.
For the response.
I'm led by Mr. Trivedi. He's at courtroom number 16 on his legs.
Section 5 application and what is the last order? 20th May of 2012 May. Suspense is the last order. Thereafter, several time matters were active.
Not today.
The only thing, several times they are asking the time.
Last date was adjourned at your instance.
My instance. But before that, not today, my lord.
Item 18.
If your lordship peruses your lordship's last order passed in the matter relating to approval of organizer teaching and non-teaching staffs, the documents we are relying on in support of our working discharge is a part of the petition, but original documents are lying with the school. We wanted to persuade the school authority kindly attend the court with the original documents so that, my lord, we can have our right established through the documents in original lying. Because
Our order is to point out the document from the record, not
records are there, my lord. Records
not
in
any new document.
no new records. My lord. Originally, we did petition, we have annexed the documents.
So where is that document which shows that you are, what do they call it, organizing teacher
Organizing teachers.
prior to 2006? So upgradation is in 2006
Yes,
and then 10th and 12th was added subsequently.
my lord. My lord, kindly, my lord, our working particulars will be available in the paper book, page 175 to 207, volume 2.
So which one is prior to 2006?
My lord, these documents, our initial appointment on 1995-96. So therefore, our appointment is definitely, my lord, no one is disputing that we are engaged there in 1995-96. That will appear, my lord, 175 onwards. This is a 2002 document, certificates given by the school authority regarding our discharge or joining of the school. Certified, all certificates, individual certificates have been given along with the qualifications. It runs up to page 207.
There is only one petitioner.
No, 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 7 in total. No, five petitioners are there. And all the 5 documents are there.
When it was upgraded?
Upgraded. Yes, my lord.
1/5/2005.
Yes, my lord. Upgraded in 2005.
Perhaps 1/5.
Upgrade cover. It was done in 2006 with effect from 2005.
1/5/2005.
Now, my lord, next document, if your lordship kindly comes, my lord. Our working particulars will be appearing at page 219, school syllabus.
It says he is working in the upgraded section.
Recorded হয়েছে 9 class 10 high madrasa 1/5
আমাদের নামগুলো কোথায় কোথায় ছিলে আমরা তো 5 জন বলে দিকে
Where's the reason order?
Recent order type it is 10/6/20.
10/6/2010, page 136.
Yes, Mala. Secretary's order, Mala, at page 136.
136.
136.
Class
Mala, only ground taken that DLIT does not contain our name. It is not our discretion. School has given an undertaking that I am organizing teaching, non-teaching staff. Mala, on the face of it, it is a wrong representation of the school. The school, Mala, documents have annexed at page 208 onwards. The schools, Mala, the vacation list and the teachers' particulars have been mentioned at page 208, 209 in 2004. In 2014, my lord, you will kindly come. And 2001 and 2, my lord, page 219. Kindly come, my lord, page 219.
What is 219?
Page 219 is a folded paper in the paper book, second volume.
Please give the class 10 syllabus.
Names of the organizing teachers, my lord, have been given in page 219 in Bengali, my lord, excuse me, my lord. That was in 2001, 2002.
Somehow this file does.
Oh, it's creating, my lord, all these tasks.
By now I should have developed immunity, but
now it is introduced, going to be introduced, my lord, all through online, on online paperless. But these are
219.
218, 219, my lord, these are not, my lord, translated copy, my lord, the original document have been annexed. My lord, these are the names of the teachers are there.
So you are not figuring in this. Your name is not.
Yes, the name is appearing. Page 219 at the middle, my lord, organizing teachers.
No, what is this is for what purpose?
For the purpose of showing that in 2001, the school is, my lord, publishing their own teaching strength, naming our presence in the said school for the year 2001-2002.
No, but that is in a primary section.
But this was in respect of the upper organized school.
So this is for the primary section.
Primary section, junior high mala section, organized teachers have been approved. There is no dispute in it. We were working, organizing the school for 9-10 upgrade section.
How the authorities can consider.
That will appear at page 221. That will appear at page 221 in the staff pattern.
Upgradation is regulated by some provision.
Upgradation, my lord, the honorable court has said that right to establish a school does not have any, my lord, condition to be satisfied by the state. I can establish the school if there is dearth of schools there, my lord, for promoting education.
Nobody can come in the way, that we know.
That we
You have a
done.
constitutional right to do that. But the thing is, the moment you seek some benefit from the state, then the state steps in to regulate the grant of benefit to ensure some kind of fairness.
Obliged.
And to ensure some standards of education. This is the law, broadly speaking. So therefore, before an upgradation is allowed, they conduct an inspection to see whether there is sufficient scope for the students to bloom in the circumstance or not.
Yes.
In terms of the number of manpower, the area, whether there is a playground, whether there are proper classrooms.
Infrastructure.
So there is a regulation before an upgradation. It is regulated by certain parameters. At the stage of regulation, if they have fulfilled the requirements in a particular way, which is to your prejudice, how the state will come into this? It will be between you and the school. How the state is
the government has given upgradation to this school.
Correct. Even if it has
recognition has been given.
Correct.
Therefore, they will not satisfied the condition precedent for upgrading a school.
We understand, but if we remember what you are trying to say is in the process of obtaining an upgradation, they have betrayed you because they have said you are not present or they are not taking any claim for you.
Exactly.
Now this is
in spite of the available documents and records that we are working.
How the state can be held liable for this? That is what we are asking you. State is there, you have no.
There is provision for organized teachers to be approved according to the state policy. I have shown your lordship on the other.
That is all right, but
if that particular provision, my lord, has been defrauded, or my lord, malpractice has been exercised to avoid the.
Remember, where is that provision? We'll see that provision. We are coming back.
Yes. Yes, at 2 o'clock.
The intra-court appeal actually, I was waiting for the oil marketing company. It's the appellate.
You are disappearing.
Actually, in the headnote, is written, this when they say that private is intra-court appeal, I misconstrued that.
May read only the headnote.
The
2 PM ম্যাটারটা সাহেব আগে নেন।
2 PM matter আছে?
Yes. 2 PM ম্যাটার item number 50. চালাও, চালাও।
That handed over the judgment delivered by this bench, Milord, regarding the 6 months tenure of a disciplinary proceeding and whether it can be extended after the expiry of the 6 months. Lordships have delivered this judgment, Milord, and last occasion when Milord we tried to.
There is a fixed period for proceeding.
No, Milord. When the first round of challenge came,
under the court's order,
the tribunal fixed a time for 6 months. That was expired, and then subsequently tribunal.
Yes, we relied upon decision of the apex court.
So that I will rely on that judgment of Lordship, Milord, and copy একটা extra আছে? Yes, I've given the report. No, just before I reach this stage, I just give you Lordship the backdrop of the incident, the allegation against the petitioner.
See, all that is irrelevant. If we are so, what is the date on which the tribunal fixed the time? By which order passed in which way?
25th July 2023. That's at page 140.
OA number?
But that was OA number 477 of 2023.
And the time fixed was 6
months. And in that order, it is recorded that if the said disciplinary proceeding could not be completed in 6 months, the entire disciplinary proceeding would be considered as vitiated.
Very well.
Lordship
So by January, it had to be done.
Yes. Now, they did not do it.
When they passed, the disciplinary authority passed the final order.
The final order, Milord, ultimately was passed on 15th of April 2024.
15/4.
April 2024.
15/4/24.
4.
15/4/24.
Yes.
Page?
That is at page 242.
And there is no application for extension
They
of
did not
time.
file any application. We, prior to this 15th/4 order, but we approached under the legal advice, we approached the tribunal saying you had fixed this time has expired, please declare the proceeding as vitiated. In that matter, subsequent to April, 16th of May, the tribunal extended the time to deliver the order, and then the 15th April order was delivered. So predated order was delivered after the extension granted after the expiry. No approach by the authority to seek any extension before the tribunal prior to the expiry.
You have challenged the tribunal's order.
I have also challenged tribunal order.
Tribunal's order passed in your own way.
I have challenged that order. I have challenged the final order of punishment.
What was your prayer in the OA? Second OA. It is OA number?
That was OA number 73 of 2024.
Where is the prayer?
Page 241.
Relief.
141. 143. Second volume. It starts from second volume. Lordship would find my prayers, Milord, at page
152.
Yes. Yes. But in this particular point was that particular point of 6 months that we have referred, Milord, at page 148. Last paragraph. May I read that paragraph that I have taken?
Where is the order passed in OA 73 of 24?
That, Milord, is at?
That is impugned in the present proceeding.
Yes, Milord. That is, Milord, at page?
No, that we have it.
240. Yes, 242. No, Milord, sorry. It's 244. 244. There is a certified copy, Milord. That portion is at page 245. The last paragraph. কপি আছে কপি আছে কপি আছে একটা কপি আছে And I've also prepared a list of dates, Pillar, for the.
What list of dates? Your over enthusiasm.
That is Pillar, I've tried to cover that in my petition, Pillar. That once the order says it automatically vitiates, I should not have approached the. That is there, Pillar. That is absolutely, Lordships. I don't know Milana, what who had advised them at that point of time, but Pillar, it was there.
So tribunal has not extended the time.
Tribunal,
The tribunal extended. The tribunal did not extend.
accepted,
It said
allowed.
only 2 months. Therefore,
Yes.
it's not a very shocking deal. There is no extension of time.
So, the proposed punishment was they were allowed to publish it.
the order of punishment. By the order, this order. Your Lordship would kindly, last paragraph of 246.
Yeah.
In view of the above observation, the tribunal is fully satisfied with the steps taken by respondent to conclude the proceeding, and therefore not inclined to consider the prayer of the applicant for setting aside of the disciplinary proceeding against him. Therefore, finding no merit in the prayer of the application, it disposed of without passing any order. Now, my lord, this permission to conclude the proceedings beyond, my lord, January, it was supposed to, the 6 months expired in January 2024, but in April, my lord, in May, this permission to conclude the proceeding,
There is no permission.
the steps taken, the
It is
fully
an acceptance
of the report which came subsequently.
It is an acceptance of the delay. That the delay is very minimal. It is hardly 2 months something. Therefore, we don't find that there is any reason. There is no either permission to. There is no specific order extending the time, nor they have been given a permission to proceed. The court has found that the steps were taken in accordance with law diligently. In the process, 2 months and something has occurred, some days, 2 months and 21 days, nearly 3 months has occurred, which is hardly anything. Even if it was delayed by a year, it was all right. That is what the tribunal has said. We are not saying that is correct, but there is no extension of time.
If I,
It has refused,
corrected in
it
that.
refused your prayer by saying that you have not been able to make out a case for holding that the proceedings stand lapsed because they have done it within 2 months, 21 days. That is what this.
I stand corrected on that. But so, my lord, I will, my lord, so my twofold argument to that is would be, my lord, one
So
is,
the only thing is, if you see that judgment, paragraph 34 of that judgment, the moment the time fixed by the court lapses, the disciplinary authority ceases to have jurisdiction to proceed with the matter. You see, read para 34 of that judgment, relying upon Prakash case, Ram Prakash case.
I am carrying that as I've got it.
His Lordship Justice Dipankar Datta's judgments.
Now, the copy the.
So how the tribunal has held it is relying on some judgment of 2015. Was that judgment considered in Ram Prakash?
But I will check that. Check koro je jeta tribunal rely করেছে 2015
Tribunal has taken note of two different judgments. One is at page.
I have tried to find it, but I couldn't get it in CCC online.
Get it.
One is Neelam Srivastav 2170.
That was there, but
The other one we don't know.
I couldn't.
The citation also is
25th, yes. I mean,
most
the
likely
page
it's a
number-
wrong.
2015-16 SCC 420. There is no judgment.
I mean, online I couldn't get it. I don't know. Found it. Huh?
আমিও পাইনি in ACC online I couldn't.
I just.
20.
It may be Miller 2015 8 SCC 519. That was in the Ram Prakash judgment. That is the only 2015 judgment considered. 15 volume 8 SCC 519. But I am
not Neelam Srivastav's
not Neelam Srivastav.
Neelam Srivastav was 21. I
Yes, that is also there. That is considered by Ram Prakash. So if I take this to be the one that then it is considered, and then this view has been expressed.
2021.
From where he has quoted this judgment?
Hasn't quoted the judgment. But
Yes, at second page, second paragraph.
Yes.
246, second paragraph. As was quoted by Land Council in the foregoing paragraph,
where it is not possible for the employer to conclude. From where this quotation is from? Which judgment?
That 2015, Lordship, I think. Lordship, it's been set out in a very different way. The pages come out first, but I couldn't find the judgment. That is, I was also. But
2015-16
SCC.
Page 420.
No,
you have a SCC online here.
I have.
Instead of 15-16, just see if it is 16-15.
There might be some error.
2016 volume 15.
This is online to check.
Whether there's anything.
I will just immediately check it.
We all commit such mistakes.
15 volume 16 SCC 420 টা পেজ নাম্বার
ওটা একটা ভলিউম 420 টাতে কিছু আসে
Instead of 15, 16, make it 16, 15.
the page
16 15 দিয়ে দেখো
the page might be
but twice it has been recorded so it,
but in the same way
yes
for page tar
একটু 420 আগে পরে একবার দিয়ে দেখ 421 বা
কিছু পাতার এদিক ওদিক
422 এর মধ্যে একবার 402 এর মধ্যে
পাতার যদি এদিক ওদিক হয়ে যায় কিছু না
402 দিয়ে একবার
So maybe this quotation has been taken from Neelam Srivastava's case.
এটা নীলম শ্রীবাস্তব কেস subject I don't think
2117 SCC 693.
it's not taken
that quotation is not I will check it once again lordship ask me to I'll check it
Neelam,
and
it was
2117
different it was
2021-17 SCC 693 2021-17 693
হ্যাঁ ওটা আছে ওটা পেয়ে
নীলম শ্রীবাস্তব
নিলাম শিবাস্তব আছে
এখানে এই কোটেশনটা আছে কিনা
না
No, I checked it.
Not there also.
I have read Neelam
I read last time it's not
So the tribunal has relied upon a precedent which we cannot trace.
we can get the entire volume we might have to look through it I was
putting the name 45 is the quotation has
No, this judgment is there.
this
But
judgment is there
this
but,
passage is
but
not
the
there in that.
2015 judgment we couldn't
So this quotation is not available in Neelam Srivastava's.
no it's not available
And this, the other one is not, the judgment is not available.
just let me
প্রেম এইটা তো বলছে তো 4201516 প্রেমনাথ বালি
এটা নিয়েছি so now we couldn't find the judgment.
No, we appreciate what you're saying, but before we record something, we must be sure. Can you just take out this passage, put it in text search? If it is there in any judgment, it will come.
This passage type the entire passage in SCC or search it up word search then find out if that is available or not. This entire passage
Because if it is there, then Ram Prakash is a subsequent judgment.
Yes, yes. It is 2025.
25 is.
Here are the copies of Ram. Okay.
And this case, this judgment we have passed in 122.
Lordships considered Ram Prakash.
That has been complied or it is?
That I don't know. That let senior colleague may say that.
Why? You can find out in 5 minutes.
No, different department maybe not in my.
You can find out whether there is an appeal pending against this in 5 minutes. Supreme Court website. It hardly takes any time.
Vishwanath Das.
for question.
Sorry, India কোনো সার্চ করে দেখো এই পার্টিকুলার ফ্রেজটা।
Automatic setting paragraph 34. Maybe I have to cease to
But Lordship's order probably is the last order in this matter so far. I have checked in 3 sites, but it's not there. No, I don't. There is no reference of any SLP pending or any further challenge from this order. Huh? No, Supreme Court.
That is why opportunity.
Yes, rarely do. You will.
Cannot be traced.
Same for the book also.
No, the judgment is probably before him. He is looking at the judgment. He is not finding that passage.
2015 judgment at the 2015 judgment. This is another 2015 judgment. It may be because 420 they record, but this is 415. This, let's see, a part of this is matching with, but may not be that. I got you kindly read this judgment. Paragraph 28. Just my junior found it. Paragraph 28.
Probably this is it.
Yes, this is from that.
This is
From middle
it's the
part
page which
is
is not
matching
there.
with that quotation.
So it is 1516 SCC, and the page on which this text is appearing is 420.
But
Yes,
the
now
actual
I
citation-
think that is the mistake they have done. The authority has done. Well, very good.
So we have unraveled the mystery. So this is the judgment there. No, this is a general proposition.
Yes, but
perhaps it appears from reading that paragraph, it is not in compliance of a court's order.
difference of this I have read. The difference of this is that there was the timeline was not earlier fixed.
That's what we are saying. Perhaps there is no timeline fixed.
That is the distinguishing part of the judgment. Paragraph 8 onwards. 24 onwards. নিচে কেন কোনটা 17 থেকে তাই বল 16 এ কমপ্লেন 17 থেকে প্রসিডিং শুরু হয়েছে আর 105 টাকা হয়েছে
Charge memo is of which year?
The charge was framed. Charge. Charge to page number 21st July 2017.
21st
July 2017.
17.
Yes, ma'am. I'll give you the page number. Page 27. 27. Page 27, volume 1 of my petition.
No, that is the preliminary. That is prior to issuance of charge memo. Memorandum is of later date.
The Lordship would kindly come to page
26/4/2019.
That is at 2019. Page 29. Yes. Page 20.
26/4/2019.
Yes. Page 20. It has the article of charges, the following pages.
That is a memo of charge. Charge memo. What was the punishment?
Ultimately, that is at page Millard 242 of the second volume.
15/4/24.
Yes. Penalty was imposed. Millard accepted the punishment proposed. The Public Service Commission accepted the punishment proposed, recommending, attached page 243, recommending that the pay of charge officer Ayan Ghosh be reduced to 3 years, street stages lower in the current pay band for a period of 3 years under Rule 84 of the West Bengal Service Clarification Control Appeal Rules, and during the period of such reduction, he will not earn any increment of pay, and the reduction of pay will not have the corresponding effect, and a total amount of rupees 82,872 be recovered from Ayan Ghosh under rule and such, not reading, because the total loss of the government was found to be 82,000 because of the alleged actions of the
2,000.
82,000. And that entire amount has been recovered from him, and that he is suffering 3 years of
He has repaid that amount.
that has been deducted from his salary. That way they have recovered the money. This part is complied, but the first portion, which is Milord, is still continuing. উপসটা কোথায়? পরে কি হবে?
Yes.
Well, one more point. Since Milord, page 28, Milord, page 28. She found the charge 29. 28 is the initiation of the complaint. This is a pseudonymous complaint.
This is a
pseudonymous complaint. Milord. There is no complainant name has not been disclosed. So Milord, this Milord, I have authorities to cite. If Lordship wants, Milord, that in respect of pseudonymous complaint, Milord, proceedings should not be entertained in the manner.
No, but in respect of this, they have conducted a preliminary inquiry. They have given you an opportunity. Thereafter, they have.
But that
is not arising. Either they can pass the order, they cannot pass the order.
That is a sole question that I have put before this honorable.
The tribunal also in the, where is that order by which it is at page 140.
Page 140 is the first. One foot. One 41 has that portion. Well, I think they kept on doing the mistake of the citation from that order itself. That citation is wrongly decoded in that order. That was only continued, I think.
That was a particular page where that.
I think so. 420, it started from here and continued.
Auction of what product?
The forest food stocks, Milord. And there was a recommendation from the authority to do it, but I will not argue those points here.
That's all. Yes.
This the second order, Lordship, the tribunal had passed an order giving a time frame. Thereafter, Lordship, when it was the same issue was again raised before the tribunal took into account there was no deliberate delay as such. It was more situation beyond the control of the respondents, and therefore the tribunal had accepted that position, and the delay was only of about less than 3 months, Lordship, as you like.
2 months, 21 days.
Once 21 days, which the tribunal who passed the order had condoned in the sense that the same issue was raised, and the tribunal taking all the facts and circumstances had, condoned the delay, and if I can put it in that way, after considering it was, he had the scope to re-evaluate his order and taking the facts and circumstances, Lordship. Therefore, he has.
Because the delay is negligible.
The delay is negligible.
You are for the commission. Heard the learned Continuing with item number 18. The order passed by the tribunal is set aside. The order passed by the tribunal is set aside.
The 5 persons are before your lordship. Out of them, 3 have already attained their age of superannuation. And rest of the two have gone out. 2 are there, they are still to spend for 3-4 years maximum for the rest. These persons from 1995-96 onwards till 2026. It is a very long time they are playing on the field. But circulars I had given to a lot of a bunch of compilation of policies.
Yes, you had given to us.
Yes. Jani. Kindly come to the said bunch, page 12. A 1994 circular regarding approval of appointment of organizing, teaching and non-teaching staff in non-government secondary schools newly recognized as 4-class junior high school of newly upgraded high school by the West Bengal Board of Secondary Education. Conditions have been given. One of the condition is their name should be in the DLIT. But the appointment of organizer teacher, my first paragraph is absolutely redundant because recognition has already been granted. Appointment only to the organizer teacher newly upgraded, which was previously already permitted by West Bengal Board. Name of such teaching and non-teaching staff are recorded in the final inspection report. Clause 3 is standing as a hindrance for me to be through to get the benefit of this circular. This has also been addressed by the government. This particular situation where the persons are working or documents are available in support of the such work, if ignored by the district level inspection team, that will appear at page 8 of the said bunch of circulars I have given to your lordship. Page 8, 6th January 1994. With reference to the above, the approval of appointment of organizer teachers. In reference to the undersigned is directed to state that in the aforesaid government order, it was stipulated that on upgradation of madrasa, the approval of organizing, teaching and non-teaching staff should be subject to the condition that names of such staffs are recorded in the final inspection report leading to upgradation of madrasa. This would mean the names were to be recorded by district level team. If the team did not do so, in the fitness of things, such team should be advised to do so after verification of the school records with specific reference with date of original inspection and incorporate the names of organizing, teaching and non-teaching staff in the inspection report. The board may take necessary action accordingly. My records speak of our existence. School is avoiding the court. School is giving a false statement to the authority. Their records I have annexed to the petition showing. This exercise has not been done. Merely saying School Service Commission has come into force from 1997. Prior to that, we were appointed. Lordship was of the view on the last occasion also. Yes, that appears to be that it does not.
What's the date of inspection? Date of inspection.
Inspection was held, my lord. Inspection DLIT. Inspection 2005. 2005. long after our engagement. Because in 2006 was the inspection will appear from the original record 2005. If your lordship can permit us, my lord.
2005.
Yes,
And upgradation was on which date?
Upgradation was made from 2006 with effect from 16th February 2006 upgraded. That is at page 101, the page.
With effect from 1/5/2005.
Now, that is class 9 and class 10 is 2006. Page 101. Page 101. First volume it is there.
How many posts were sanctioned and how many have been regularized?
But in the 4th-class junior high schools, কতগুলো sanction post?
No, you are now claiming in 9th, 10th.
6 posts are there in the, well, so far as the junior high status is concerned. So far as the staff pattern is concerned, well, 6 posts are given for junior high up to class 8. And 9, 10, my lord, are further 6 posts are given. Therefore, it goes up to, my lord, more than 12, 13 posts.
12. All 12 have been
that is 12 posts will appear. My lord, we have given in our compilation at page 15 pattern of distribution of staff.
No, that's all right. What we are saying is whatever was the sanction post
12
for 9, 10, that is filled up.
12. No, not filled up. 5 posts are still lying vacant right from the day. Because there is an injunction of this honorable court not to fill up. Justice Soumitra Pal's order I have shown to your lordship. That is also the part of my compilation. Page 135, the paper book.
Don't rely on our memory. Please show us. Page
135 of the paper book. 134. Okay. Justice Pal's judgment at 134, volume 2. That was 12th of April 2006. This read petition copy does period D.
This was disposed long back.
That injunction continued. Though no appointment has been given, right, wrong, indifferent.
How an injunction can continue beyond the disposal of
that is your lordship's prudence is showing so. State did not say so, my lord. We are working, we have continued to work.
That's a
Finance is not being spent. Benefit of the state is that I am not spending any finance too. I am free of cost. I am getting the service of teachers. Let it go. Why the government public exchequer will be burdened? That was the temperament of the state. Exploiting someone. We are only paying no area dues be paid to us, my lord. Approval with notional benefit will be given to us. So that, my lord, the persons who have gone out, who are there,
anything can be given after you are regularized.
That is your lordship.
How to regularize? That is the point.
A regularization direction has been given by this court. I have showed the judgment to your lordship, my lord, on the identical issue. Justice Harish Tandon sitting with my lord Justice Vishwas, had pronounced the said judgment. Lordship. That judgment I have shown you, lordship. Judgment Justice Tandon judgment.
1497.
Page 334. The judgment is annexed.
334 of the paper book.
Of the paper. One volume there. Third volume. My lord, I placed it, lordship was considering, lordship said that this is for junior high. I have cited your lordship the circular that which the junior high and upgraded school are covered by the same circular. Same treatment has been allowed to be done. All judgments have been considered. Supreme Court order has also been considered by this Honorable Court. Lordship had said the court relied on the Prabir Kumar Ghosh's judgment at page 346, my lord. At the Honorable Division Bench, my lord, considered it and quoted the judgment itself. Second paragraph of the said page. কোথায় আছে? কত আছে? নেক্সট এটা নেক্সট আছে? আলাদা এক্সট্রা কপি আছে না? একটা কপিতে The Supreme Court was considering, in the case of Prabir Kumar Ghosh, a division bench judgment of this honorable court denying our claim.
Yes, the single judge had allowed your claim, division bench interfered.
This is the view of the division bench.
No, we have seen it. It is considered in this judgment that you are relying on. Because Prabir Kumar Ghosh has been relied upon by his lordship.
I am not that. Prabir Ghosh, my lord, was an appeal against a division bench judgment of this court,
Correct,
my lord,
correct.
where my right was denied. This is
Yes.
a detailed judgment, my lord.
The single judge held that since you were imparting education, there was a report of the district magistrate supporting your existence. Therefore, there was no occasion to deny the regularization. The division bench said no, it was not an appointment in accordance with law. Therefore, you cannot claim a regularization.
My lord.
Apex court said no. The judgment of the we reaffirm or we uphold the decision of the single judge. That is, we have seen that.
This is how we stand today, my lord, to your lordship, my lord. We leave it to the mercy of your lordship, my lord. These three two first.
We have no mercy jurisdiction.
But this is, my lord, I have, as the best of my capacity.
See, no, that we have understood what you are arguing. We'll consider this judgment. We have to consider the policy that you have relied upon. That we have to consider, and just that provision under which the regularization. Can you just refresh that provision? That is the 14 January one. That is the provision.
Yes, that is only. There are no particular rules, my lord. The circulars, my lord, are governing the organizer teachers.
No, there is some rule or act which has come into force.
1997.
Yes.
That was recruitment rules came. Whether the recruitment rule will apply or not, so far as those persons recruitment rules speak of, clause 9, that the person after coming into force of the said rule, no appointment should be given other than recommendation.
We had seen that, if we remember.
Service Commission Act.
Where is that?
Page 32 of the paper book, part 1. Compilation page 32. Sorry, Bella. Compilation page 32.
12, that serial number 12.
Yes.
Index serial number 12.
My lord. Index serial number 12.
Yes. What do you have to say about this judgment? Prabir Kumar Ghosh judgment.
This judgment was point that can be differentiated, lordship, in this judgment. They were found by the DL. The names of the teachers existed in the DLITT report. Here, there is no, I mean, here we have given recognition on the, based on the affidavit that there are no organizations. This is a very basic, because here the teachers were there. But in this particular case, lordship, the recognition has been granted, lordship, ceasing view, lordship. The undisputed fact, it is undisputed that the madrasa had undertaken before the authorities that no organizer teachers are claiming any benefit from the state. And based on that undertaking, recognition was granted. Therefore, lordship, according to the resort to the School Service Commission rules for that. So this is a very, the judgment of Prabir Ghosh and the facts and circumstances of the case.
That undertaking part has been taken care in Justice Pidaki Ghosh.
That we have seen. That was at the stage of inspection.
Inspection. That is what my learned friend is saying. Inspection did not record.
That is at the stage of that. See, in that those persons came forward. That look, they are pressurizing to omit our names. Then the
candidate came. School does not come.
Yes, those persons came to say that they are omitting our name in the inspection. They are being forced to give a declaration that there is. Then this court said that that can't be done.
No rule is there.
Yeah,
Giving an undertaking. How they can ask for the such undertaking? Is there any provision in the law that the school is to say that there is no organizer teacher is there? Only to avoid this.
Yes, that was
one last prayer to your lordship. If your lordship so feels, lordship may give a direction, let the school appear before your lordship. Because it touches our fate to survival.
They were not appearing before the single judge.
They did not appear, but your lordship can direct them. Let them appear and say, if they say no, my lord, I will be going out of the
They
court.
have given an affidavit. How can they contrary to the
They have
affidavit?
to say, my lord, their false statement has been made to the authority. In spite of the
Come to page 97 of your volume 1.
Yes. They have made an affidavit. That is exactly what I say. But absolutely opposing the existence of ours. My lord, this particular statement was taken for the purpose of getting recognition. There only
And where is the reasoned order passed rejecting your claim?
impugned order. The reasoned order authority.
Yes.
That is only point that reality does not contain our name. That was the reasoned order.
No, just we want to see.
That is the only point. Page 162.
136.
162. Third volume. Second volume. Second volume 162.
Oh, this is the reason.
There are 3 orders. One department, one principal secretary said that yes, organizer teacher should be appointed. Second one, another person came to follow up the order. The court said, you consider. Second round, they say, no, not entitled. Third round, went to the chief secretary. Chief secretary says, not entitled. This is, someone is getting benefit out of it, but someone is denied the same. No, regular principle is there. Court is passing orders, but these persons are getting the approval. And there is no much financial. They have already exploited us, but not paying anything. I am not asking for payment even. I am asking only the notional benefit be given so that the persons who have retired, let them get the at least pensionary benefit out of that. Qualifying service treating without making any payment, only pension. And some persons, they are also required to be treated as qualifying service, for the purpose of concluding their 3-4 years, left out. Let them survive. I appeal to your lordship. If your lordship feels that yes, some relief can be granted, if I could satisfy your lordship with my limited efforts, that some orders are there which might, my lord,
What is the date of this affidavit at page 97? It's hardly legible. You have got a typed copy. Otherwise, nobody can read it. What is the date?
এফিডেভিট ডেট আছে ওদের এফিডেভিট যেটা ফাইল করেছিল 97 না 95
2004. 4. Very well, we'll pass the order. Just the writ petitioner Item 19.
This is hearing for the first time to go to the papers and
The determination of the present bench deals with send it to the department. 3 weeks. Send it down. You do whatever you are required to do. Yes. Huh? Just write matter made returnable after 3 weeks.
এটাকে একটু দেখে নিন বাবা স্টেজটা কি রেকর্ডটা দেখে সরে চাইছে
রেকর্ডে যাইছি। Item 20. Item 21. Next one. 22. Both sides are present. 22. Next. Item 23. You are for?
Respondent.
Next. Item 24. Both sides.
Yes, both sides. Mr. Mohapatra, the learned advocate, is appearing for the respondent. My lord, just to remind your lordships, the my lord, respondent was a constable in the CISF. Now, at that material point of time, when the incident occurred, at that time, he was not envisaged with any duty. That is an admitted position. Yes, your lordship. I am grateful. Now,
Outside the
yes, and outside, and what fell from your lordship on the last occasion, as I remember, subject to correction, that from the evidence, apart from the doctors, whether is there any clinching evidence with regard to any contradictions of the accused with regard to the incident. His defense was that I fell down. I went to the do some work in a bank. The branch manager, if I am wrong, Mr. Mohapatra is here to correct me. Branch manager at that material point of time was not there. So he get depressed. Now thereafter, he came to a river bank. He fell down. Some people were drinking alcohol on that. No privity of contract between the accused and those people. Now they poured alcohol on him and he didn't drink, etc., etc. Now, first I want to.
And what is the punishment?
Punishment, my lord, the disciplinary authority passed an order of punishment for 2 stages.
Lowering of
Lowering with culminative effect.
For how many years?
For 2 years.
3 years.
Yes.
Cumulative effect for the whole.
For the whole. For the whole. I stand correct. For the whole. Thereafter, my lord, an appeal was preferred, my lord. In the appeal, the I'm sorry. Suo moto, the order was enhanced to compulsory retirement. Against that, he filed a writ petition before Justice Biswas, as his lordship then was. Now, Justice Biswas direct the appellate authority to consider afresh. It was considered, and the same punishment remained.
It was maintained.
Yes, maintained.
Compulsory retirement.
Compulsory retirement. Now, এই সাক্ষীটা দেখো, আমার তো একটা কপি জেরক্স দিয়েছো ভাই, জোসেফ থেকে দেখো।
So the charge is
রিটটা দাও, ভলিউম গুলো দাও, দাঁড়িয়ে থাকো না ইডিটের মতো। Yes.
What is the charge?
Yes. এটা কি ভলিউম 1? Yes, just a minute. Your lordship kindly takes my stay application. Article of charge is at page 34, my lord. Just a minute. Yes, may I please? 34. Volume 1. দুটো ভলিউম আছে। May I please, my lord?
No, we are reading. Please.
Yes.
Give us 2 minutes.
Yes. সাক্ষীগুলো রাখো, সাক্ষীগুলো রাখো। নাম দিয়ে দিও, সাতটা। তোমার সিনিয়র তো স্টেটমেন্ট জায়গাটা দাও, ভুলভাল দিও না। একটা দিনেশ্বরের আছে কোয়েশ্চেন, আমি সেটাও বের করে দেবো, পয়েন্টটা করো না। আচ্ছা, মাত্র ট্যাগ করা আছে, তুমি কি মাঝে মাঝে হয়ে যাও নাকি? দেখে মাত্র কোন কোয়েশ্চেন ভোট করো না। এর সঙ্গে
আগের কথা ঠিক আছে ঠিক আছে ঠিক আছে জাজমেন্ট গুলো গুছানো আছে যে জাজমেন্ট গুলো গুছানো লাইনে আছে তো সুপ্রিম কোর্ট টেক ইউর সিট না না কোনো দরকার হুম। And Article, my lord, 3, that is the third charge, as your lordship, my lord, have perused, subject to correction, it found that he is a habitual, my lord, defaultee, yes. Yes, yes. So that is also a reason which prompted, my lord, I am grateful. My lord. Now, on what fell from on your lordship's last occasion, may I place, only I will be placing the relevant part. আমার কপিটা কোথায় যেটা ট্যাগ করা yes my lord I have translated because the statements are in Hindi for your lordship George Sahib to them. I will be taking your lordship to only these are the translated copies.
Charge Article 3
Yes.
would assume significance only after the charge 1 and 2 are proved. Ipso facto, charge 3 cannot be made the basis of any punishment.
Absolutely, absolutely. I bow down to your lordship.
Charge 1 says that he has indulged in some fighting or something. There is nothing on record in support of that.
No eyewitness.
There is nothing on record. I have just gone through the statements recorded in the inquiry.
Yes.
All of them say we learned that he was lying by the river in a pool of blood. None of them say that there was any fight with anyone. Some person, some boy came, he said 12-year boy said that he's lying on the riverside. So from the charge number 1 is that he has indulged in fighting with some unknown persons. But in the inquiry, there is nothing regarding any fight by him.
With greatest respect, there is a contradiction of the statements of the accused respondent himself. My lord, may I just take your lordship to that, my lord? If your lordship...
And second charge is an addition to the first in the sense that he had consumed alcohol.
Yes.
That is backed by medical report.
Where is the report?
Report is marked as Exhibit 5.
Exhibit
5. My lord, before that only may I produce this statement, my lord. I will be coming to the report. If your lordship kindly.
No, it is 7, 8. Copy of medical report 19/5/2008. Where is this? Just give us the page number. We'll come to that.
Yes.
Just give us the page
Yes,
number of
the report.
medical report.
The report.
Perhaps it is 19/5/2008 because that is the day on which he was.
19/5/2008.
That is the
Yes,
date of
yes.
occurrence.
Yes. Yes, sir. আমি তো রেকর্ডটা দিব আমার ভলিউম থেকে না রেকর্ড থেকে দিব রেকর্ড দেখতেছি ট্রান্সলেশন দিলেন ওটা রেকর্ড ট্রান্সলেশন দাও দেবেন না হ্যাঁ দিয়ে দিয়েছি দিয়ে দেবো আমার কাছে একটি গ্লাস কপি দিয়ে দেবো এক্সট্রা কপি আছে ওই ট্রান্সলেশন দিয়ে দিচ্ছি বলা আছে ডাক্তারের সাক্ষীরা কোথায় আছে রাঠি তাই তো ডক্টর রাঠি তো
Yes. So there is a smell of alcohol in this report.
Well, in the statement of the doctor, there is.
Where is that statement?
Yes, your lordship kindly. My.
His witness number.
Yes. Well, the doctor statement of Dr. Rathi, that is page 48 of my typographical copy, my lord, which I have given to your lordship.
This one.
Yes. May I place one? Yes.
Yes, a smell of alcohol coming from his mouth.
Yes. And alcohol-like smell was detected. And after medical treatment, he was discharged from the hospital and advised to take rest for 1 week. So that is corroborated by the evidence of the doctor. Now, if your lordship, what fell from your lordship, I am extremely grateful. Shaki copy to the. Yes, your lordship kindly comes to the translation of the evidence of the my lord respondent. That contradiction I want to
statement.
Yes, statement at page 50. The typographical copy, my lord.
The first page.
No, 50. 50. Lordship, God, my lord. May I read the answering part? I had gone to the bank. That is his own statement. But the manager was not there. It was going to take time for him to arrive. So to pass the time, I went to the river bank. I sat there for a long time. At that time, I was suffering from mental stress. When I got up to leave from there, I fell down. Some people who were sitting nearby have a picnic started laughing at my fall and gathered around me. Instead of showing sympathy, they started verbally abusing me and got into a scuffle. They had alcohol in their hands, which they spilled on me, and later they threw it on me. My psychiatric medication was going on, which has run out. That means admitted fact that he's facing some mental problem. That is admission. The injuries on my forehead and below the left eye were caused by my fall and not during the scuffle. He tried to, my lord, distinguish the injuries. দিচ্ছি।
Yes, we have seen.
Now, thereafter, your lordship kindly take the trouble to come to the next page. Question number 4. Regarding the incident that took place on 19/5/2008 at such and such, you gave a statement on 25/8 during the preliminary inquiry. In that you stated, I sat by the river bank for a long time. When I got up to walk, I felt dizzy and fell down. Due to the fall, my face hit a stone. Now here your lordship kindly sees a new story of falling down in a stone is coming. It got injured and started bleeding. While I was walking, visualizing a staggering motion, I collided with a person, leading to a physical scuffle with him. That person then ran away from there, and I started moving to my unit lines. About next page, about 50-60 meters before the main gate of NHPC unit, next page, a Tata Sumo stopped near you, in which the corps commander along with such and such. So, what I want to impress upon your lordship, that, my lord, during the statements of the delinquent, my lord, he has himself contradict. That leads to disbelieving of the entire incident. Once he said, I fall down, some persons were there, unknown persons were there, they were laughing at me, and thereafter they poured me alcohol. Where admitted fact is that there was no privity of contact, no enmity with the delinquent, with the said persons. Now he comes with another story that he fell down and he got hit in a stone, and thereafter when he was moving, he got with a hit by a person. So this is the contradiction part. Now, my lord, so far the evidences of the prosecution witnesses are concerned, my lord, there are all the prosecution witnesses in a same tune, my lord, stated that yes, when they were moving by the car, they have seen the accused with bleeding injuries, and immediately when they take up by car and went to the hospital. And that smell of alcohol and all that was also in the evidence apart from the doctor in the prosecution witnesses. Now the question, my lord, which falls down for consideration, kind consideration before your lordship, that what the honorable single judge, with great respect, my lord, prima facie of the opinion that as because on that day he was not in duty hours, so the punishment imposed upon the delinquent is disproportionate. But my respectful submission, so far the CISF Act is concerned, as your lordship knows better than me, so far section 15 is concerned, my lord, it means that every member of the force shall for the purpose of this act be considered to be always on duty and shall at any time be liable to be employed at any place within or outside India. So that is there. They are paramilitary force. Utmost diligent, utmost strictness is necessary.
This provision fell for consideration before the apex court.
Right.
In one judgment which I had the occasion of seeing.
My lord.
What does it mean when it says on duty?
That my lord, judgment I have to look into. Well, other judgment on the similar point, which I brought, my lord, before your lordship, my lord, that states even a paramilitary force is not in duty hours. So that means at that material point of time, his duty is not envisaged. Even then, this type of act tantamounts to misconduct. Now, if your lordship, my lord, allows, I can place the judgments.
Why not? Yes.
Yes,
You place it. So there is a degree of conduct which he requires to maintain.
Yes.
So that the
and
impression and perception of the force
Yes.
at large does not
Yes.
fall in the eye of the public.
Yes.
Relying on that, perhaps the judgment was passed that
My lord.
you are required to maintain a particular degree of
Yes. And another
decency and all this.
absolutely, absolutely. Another thing, your lordship, kindly, my lord, appreciate that at the time of my lord enhancing the order of penalty, suo motu, by the appellate authority, my lord, they had not chosen to, my lord, pass any harsh order of, my lord, removal from service. The order was modified to compulsory retirement.
What is the consequence? He gets any benefit?
Yes. All benefits. All benefits. Yes. Pension, gratuity, all benefits. So.
And what was his age at the time?
Now.
At the time of the punishment order.
Now he's 65. Now he's 65. Well, the first one which I like to place before your lordship is the judgment of Honorable Supreme Court, that is Union of India and others versus Colonel Sunil Kumar. I will be taking your lordship to paragraph you will, sir, get a chance to reply, don't worry. Para 3.1.
Not given him copy of the judgment.
I will give man. All the judgments I will give man. After conclusion, I will give man. He will get a chance of reply.
Yes.
Yes. Your lordship, kindly come to page 4. That is 3.1. It is vehemently submitted by Miss Diwan, learned ASG, that the penalty of dismissal from service inflicted upon the respondent was after conclusion of the departmental inquiry and after holding the charges and misconduct proved against the respondent delinquent. It is submitted that the charges and misconduct proved against the respondent delinquent were very serious and not befitting a soldier working in the discipline force CRPF. It is submitted that while under the influence of intoxication, he misbehaved with senior and threatened him of dire consequences, thus committed an act of just a minute, insubordination. It is submitted that therefore the order of penalty of dismissal, which was passed after following the due procedure as required under under Rule 27 of CRPF rules 1955, cannot be said to be disproportionate to the charges and misconduct proved. It is further submitted by Mrs. Diwan, learned ASG, that order of penalty of dismissal was imposed upon the delinquent respondent in exercise of powers under Section 11 of the CRPF Act 1949. It is submitted that Section 11 of the CRPF Act enables the authority to impose minor penalties stroke punishment other than suspension or dismissal. It is submitted that reliance placed under Section 9 and 10 of the CRPF Act 1949 by the Division Bench of the High Court while interfering with the order of penalty of dismissal imposed by the disciplinary authority on the ground that the respondent delinquent was not on active duty. Similar point, my lord, was not on active duty when he committed the misconduct, and therefore the same can be said to be a less heinous offense, and therefore the order of penalty of dismissal is disproportionate, is absolutely misplaced. It is submitted that as such the consideration of heinous offense or less of heinous offense would have bearing on order of imprisonment as provided under Section 9 and 10 of the CRPF Act 1949. It is submitted that it would not have any bearing on imposition of penalty of dismissal under Section 11 in an appropriate case after holding the disciplinary proceedings. Relying is placed in such and such. Now, thereafter, your lordship kindly skip 3.3 and kindly come to 3.4, next page 7. I'm sorry. It is further submitted by the learned.
Yes, we have seen. Not
Yes.
only disproportionate, it has to be
Yes.
shockingly disproportionate.
Now the second one, that is, my lord, 2022, volume 1, SCC 373, Union of India and others versus ex-constable Ramkaran is 373.
This is on which point?
It is, my lord,
You need not multiply the judgment on the same issue.
Multiply disproportionate.
So therefore, what is the difference between the two judgments?
No, more or less on the same footing.
Then which one we should consider? You tell us.
But this is a current judgment, my lord.
So we'll consider this.
May I just a minute, may I just my lord, here, my lord, there is a slight difference. My lord,
Talking to the conscience.
Yes.
So there is just his
Talking to
lordship
the
Justice
conscience.
MR has also said the same thing.
Yes.
Not only disproportionate, shockingly
Yes,
disproportionate.
and here, my lord, subject to correction, if your lordship kindly allows me, my lord, to place 27, page 383. Here, my lord, the Supreme Court, if I understand correctly, opines that High Court would not be in a judicial, my lord, review by, my lord,
Precisely same thing here.
changing the, my lord, quantum of judgment.
Unless shockingly disproportionate.
Changing the quantum of judgment. It can send to remand, but it cannot change by its own.
Paragraph 27.
Paragraph 27.
So it cannot.
Yes, adverting to the facts of the page 383, adverting to the facts of the instant case, the High Court, in our considered view, fell in error in interfering with the punishment which could lawfully be imposed by the departmental authorities for his proven misconduct. The High Court should not have substituted its own discretion for that of the authority. What punishment was required to be imposed?
Here, what punishment has the High Court directed to impose?
My lord, in our case, my lord, the High Court has set aside the order of, my lord, compulsory retirement, and, my lord, affirm the order of the disciplinary authorities of lowering of 2 stages with culminative effect on its own. এটা কোনটা দেখাচ্ছে? এটা কি পয়েন্টে? And the third one, my lord, that is passed by, my lord, our High Court, my lord, division being comprised of the Honorable Chief Justice, as his lordship then was Justice Shivangam, my lord. The powers of the High Court at the time of, my lord, I will be taking your lordship to only paragraph 9, 10 and 11, page 3. সবগুলোই দিয়ে দেবেন, মহাপাত্রটাকে সব দিয়ে দেবেন। হ্যাঁ, নিশ্চয়ই, কেন বলবেন? Firstly, we need to point out, inner page 3, para 9, that the level of discipline to be followed by a member of a paramilitary force is much higher than that of any other employee who is employed in any other civil service. Therefore, the question of whether this scuffle occurred or not, how it occurred, and what precipitated this scuffle, etc., is of no consequence when admittedly there was a scuffle in which 2 people were involved. Which paragraph? My lord, paragraph 9, my lord, of the judgment, inner page 3. The parameters, my lord, between, at the time of consideration, between a paramilitary force and a ordinary civil servant, which 2 people were involved, that is the respondent writ petitioner and the constable J.B. Singh, and both have been removed from service. Therefore, the question of interfering with the punishment imposed on a person who is a member of a disciplined force, paramilitary force, is beyond the jurisdiction of the court exercising power under Article 226 of the Constitution of India. Even assuming the court exercise of a finding that the punishment imposed is disproportionate, the procedure to be adopted is to send back to the disciplinary authority for consideration of appropriate punishment instead of punishment of removal or dismissal from service. So here also, my lord, the Honorable Division Bench of this court held data work, and in the last page, my lord, that is a penultimate paragraph, page 6. Therefore, we are of the clear view that the order and direction issued by the learned single bench was beyond the jurisdiction of the court, and an error of law has occurred while doing so. For the above reasons, the appeal is allowed, and the order passed by the learned single bench is set aside, and the punishment such and such stand restored. So, my lord, this is my humble submission. Now,
Yes.
I will hand over all the judgments to my learned friend, my lord, in course of tomorrow. The lordship may hear him.
Tomorrow we can conclude, or you want?
You also can cut tomorrow, my lord.
Okay. We have heard the